if it's $1 million, you're not really going to believe me, are you? Did I really believe I had the legal right to keep $1 million? It's not quite so convincing. So it depends on the amount of money, doesn't it? To some extent. But the key point to remember here is it's all about the defendant's belief. So is that objective or subjective?
Subjective.
Subjective. You're good students. I was told you were good students, and you are. It's good. So many students get that wrong. It's subjective. Okay? Let's try the next one. 2.1b. A person's appropriation of property belonging to another is not to be regarded as dishonest if he appropriates the property in the belief that he would have the other's consent if the other knew of the appropriation or the circumstances. So, belief in the owner's consent. Yeah? So, if I find 1,000 taka in the street, okay, and I decide to keep it, do I have the owner's consent? Let's test it. If the owner found out, would the owner say, "Oh, keep it"? I don't think so. I think the owner would want the money back, don't you? Yeah? Okay. But be careful. It's not about the owner actually consenting. What is it about? It's about belief. So, it's not about what the owner thinks, is it? It's about what I think. Okay, so if I find this in the street, I might say, yeah, I found the money in the street, I know it's not mine, but you know what? I just assume that whoever's lost that doesn't mind me having it. Now, the owner might mind, but what's important is what I believe, isn't it? And again, it's subjective, okay? So if I honestly believe that the owner wouldn't mind if they found out, then I'm not dishonest. So, let's look at the third one. A person's appropriation is not dishonest if he appropriates the property in the belief that the person to whom the property belongs cannot be found by taking reasonable steps. Does that sound promising?
Yes.
I think that sounds promising, doesn't it? Okay, so you find 1,000 taka in the street. Are you dishonest? Question. Do you believe the owner can be found by taking reasonable steps? If you find money in the street, it could be anybody's, couldn't it? They could be long gone. Okay? Now, unless you're going to be like our noble student here and take the reasonable step of saying, anybody lost this money? Actually, I think you would endanger your personal safety if you were to do that. Okay? I think you would be killed in the rush. But if you think that's a reasonable step, fine. But whose belief is important here? Defendant. So I pick up this money in the street and I think, oh fine, I'll have that. Don't know whose it is. Can't find out. Okay, I'm going back to London tomorrow. I can't really make inquiries as to whose it is. Okay, so do I honestly believe that the owner cannot be found? Yeah? Okay, in which case, am I dishonest? No. So those three tests are very interesting and very important, because when you're looking at dishonesty and theft, those are the three you go to first, and you do them in that order. Okay? Honest belief that it's yours in law, you've got the right. Honest belief that the owner would consent if they knew. Or honest belief that the owner can't be found by taking reasonable steps. Now, I have to say, the majority of defendants who are going to escape liability of theft because they're not dishonest will do so on the basis of sections 2.1a, b or c. Most people who are not dishonest fall under those three. And there are some who would argue that those are the only tests that you need. Some people would argue that if you don't escape under 2.1a, b or c, then you should be dishonest. Okay? However, English criminal law has one other little trick up its sleeve. let's go back to one of my examples. Do you all remember the example about the starving animals? Yeah? Okay. Let's test that one. Remember, you've been put in charge of the animals, there's plenty of feed. Farmer says, you must not feed my animals. The animals are about to die of starvation. So you decide to feed them when the farmer goes away. Okay. We know that you've appropriated property belonging to another and you had intention to permanently deprive. Everybody happy with that? Okay. The only issue between you and a conviction for theft is whether or not you're dishonest. Yeah? Okay. How do you test it? Let's go to section 2. 2.1a. Do you honestly believe you've got the right in law to feed the animals? I don't think you do. Let's make the example even harder. You're a law student working for the farmer. Yeah? Do you honestly believe you've got the legal right to feed the animals? No. That's not going to work. Okay? 2.1b. Do you honestly believe the farmer would consent if he knew you were feeding the animals? He'd given you instructions. Good. What did he say? Don't feed the animals. So are you going to be able to rely on 2.1b? No. Alright. 2.1c. Do you honestly believe that the owner of the animal feed cannot be found by taking reasonable steps? No, I don't think so. You know who exactly it belongs to. So, here is a case where you might have some sympathy with the defendant, and yet the defendant cannot escape under 2.1a, cannot escape under 2.1b, and cannot escape under 2.1c. Now, if there was no other approach to dishonesty in English criminal law, that defendant would be guilty of theft. But there's something about that example, and you think, that's not quite fair, is it? There's something not quite right. Which is why, if we just click on, which is why we have the common law approach to dishonesty. Everyone will be familiar with the case of Gauche, okay? It's not a theft case, it was a deception case. That's why the issue of dishonesty was at large. But it was actually about someone claiming for work they hadn't done because there was other work they hadn't been paid for. Classic dishonesty issue. And what we see in Gauche is effectively the Court of Appeal saying, well, dishonesty, is it conduct or is it a state of mind? That classic dilemma that we outlined a moment ago. And Lord Chief Justice Lane offering us this two-stage approach. And he says, in determining whether someone was dishonest, first question, was the conduct dishonest according to what reasonable and honest people would do? So that's a kind of objective test. By the standards of reasonable and honest people, was it dishonest? So if you're on a jury and the defendant has fed the farmer's feed to the animals, would you regard it as dishonest to feed those animals? No, probably not. Now, the way it works, of course, is that if the answer to that first question is no, reasonable and honest people would not regard it as dishonest, what happens? There's an acquittal. End of case. It goes no further. Okay? Now, there might be a few really mean people on the jury. And they might say, no, I'm sorry, the farmer told him not to feed the animals, or told her not to feed the animals. I think that's dishonest. Well, then we go on to the second question. Whether the defendant must have realised that what he was doing by those standards was dishonest. Subjective or objective? Subjective. Did the defendant realise that ordinary decent people would regard that as dishonest? Now, that's where it becomes very difficult for the prosecution, doesn't it? Because a defendant can simply say, I didn't think that ordinary decent people would think it was wrong. I honestly believe that's what any decent person would have done, is feed the animals. Now, if that's true, is the defendant guilty of theft? The answer is no. Okay? So, what we can see, in summary, is that actually, English criminal law doesn't actually define dishonesty. What it does, it gives you a partial negative definition in the statute. And then after that, what you've got here is actually a direction to the jury on the questions they should ask themselves. This doesn't really tell the jury what to think in terms of the outcome. It is just a process direction. These are the questions and this is the order in which you must ask them. So actually, we've arrived at a very interesting situation in English criminal law, whereby, apart from section 2(1)(a), B and C, it's up to the jury to determine whether or not something is dishonest. And can you predict how a jury is going to go? No. Can you ask the jury how they arrived at their conclusion? No, you can't. Section 8 of the Contempt of Court Act. You go to jail if you do that. So we'll never know, will we? Which is why, tactically, one of the most important decisions that a defending counsel might have to make in a theft case is whether to go for jury trial or not. And that requires a very good assessment of how the jury are going to regard the defendant, the extent to which the defendant is seen as a sympathetic character, the extent to which the defendant is seen as a plausible character. I did have a quick look at what the Bangladesh Penal Code says. Boy, the Bangladesh Penal Code is complicated. It's really complicated. The definition of theft is actually quite like the Theft Act 1968. But what you don't have is a definition of dishonesty. So we're told that theft requires proof of dishonesty under the Bangladesh Penal Code. And it says that whoever does anything with the intention of causing wrongful gain to another person is said to do that thing dishonestly. So the Bangladesh Penal Code does look at intention. Whose intention? The defendant's. So objective or subjective? Subjective, okay. But then it goes on to define wrongful gain or whatever as relating to whether you're legally entitled. So it's interesting to compare the two. The Bangladesh Penal Code is much tougher than the Theft Act 1968. You do not have all those escape routes that are built into the Theft Act 1968. So if I was going to be prosecuted for theft of John's money, where would I rather be prosecuted? Dhaka or London? London, every time. Because the Theft Act 1968 offers me 3 escape routes to liability. Interestingly, the Penal Code here doesn't do that. So, just to close, you might want to think about what are the right answers to our examples. If you keep money and you find it in the street, are you going to get away with it? You probably are. Okay, 2(1)(a), 2(1)(b), 2(1)(c, any of those might work actually in relation to that. Depends what you think. Pay too much money by your employer? 2(1)(a), might you believe you've got the legal right to keep it? You might believe that. And that might be enough to stop you being guilty of theft. Given too much change in a shop? 2(1)(a), might you honestly believe you can keep the change? I think you might. That would probably protect you in that situation, okay? Taking property from your employer because you feel underpaid. Might you believe you've got the legal right to do that? Might you believe you've got the legal right? You might believe it. You don't have the legal right, but you might believe it, remember. Okay? And the last one, taking the food from the farmer, I think we've seen 2(1)(a), B and C doesn't help you, but what does? Test and gauche. And provided you've got a reasonable jury, I think you'd escape liability on that one. Okay, very quick tour of dishonesty. I hope that was a useful refresher for those who've done it, and a bit of useful preparation for those of you who haven't done it. Have you got any questions about dishonesty? Or I've exhausted your curiosity? Do I know who the owner is? Yeah, so that's not going to work, is it? So 21A might work. If 21A doesn't work for some reason, how about Gauche? Would ordinary decent people regard my taking of the gun as dishonest? I know he's going to murder someone with it. So would they regard it as dishonest? No, I don't think so. So I think I'd escape liability under the first limb of Gauche anyway. That's one way of tackling it, by taking his gun. Okay? And that's a slightly less certain situation. But if I can show evidence that there's defence, so in the short term, that may be a more straightforward way of doing it. That would be a good little exam question, I think.
The employee takes some money from the employer, intending to return it back.
Right.
In that case, what will happen?
Okay.
Section 2, subsection 2.
All right, so it takes some money from the employer. Let's suppose he takes 1,000 taka out of the cash register and he intends to return it maybe the following day or something. Okay. Let's just go through the elements. Is it property?
Yes.
Yeah. Does it belong to another? 21A. Might he believe he's got the legal... That is... The prosecution. They've got all the powers of the state. Okay? So you're quite entitled to sit there and say, I believed I had the legal right. You proved that I didn't believe that. And if you're a half-decent defence lawyer, that will be your approach. Okay? It's not your job to help the prosecution, is it? Okay? Your job is to say, you make the allegation, you prove it, and you prove it beyond all reasonable doubt. So, you get asked this question all the time. Now, people say, well, the defendant could just lie. Well, they can to conduct the case properly if they get away with it. So, I can say, I posted the letter. Okay? You've got to prove I didn't. So, thank you for your attention and your time. It's a pleasure doing this honestly. Have I got a witness? Money back?
I'm going to give you 2,000. Thanks so much, Mike. Yeah, really quickly, guys. I know you're probably waiting for lunch and stuff. I just wanted to thank you for your time today, really. To Khalid and to Sharia for inviting us. So I'm just making sure I got that. For inviting us to visit with you guys again, and hopefully you enjoyed the lecture. I think I've met some of you this morning and asked various questions about the university. We're going to be around for another couple of hours this afternoon, and I'm already talking to Sharia about coming back in June for the annual open day that you guys have as well. But if you do have any questions about studying at London South Bank University, I'd love to answer them this afternoon. I can give all my contact details as well to Sharia, and I can put them on the LCLS Facebook page or things like that as well. And if you have any other questions, or you just want Mike to come back and give further lectures, I mean, I'm probably the only person in this room that hasn't got a law background, so obviously that didn't make any sense to me, other than that if I believe it, I think I can keep it. Is that right? Whatever it is, I don't know. But yeah, thanks, Mike, that'd be great. So yeah, just thank you all for your time, and if you do want to come and say hi this afternoon,